The European Data Protection Board's updated guidelines aim to standardize the process by which supervisory authorities determine administrative fines for GDPR violations. These guidelines supplement prior advice on when fines should be levied, focusing instead on quantifying fines in a way that respects the regulation stipulations for effectiveness, proportionality, and deterrence. A crucial aspect of the GDPR is its empowerment of supervisory authorities to enforce data protection laws more robustly, with significantly increased fine ceilings intended to ensure compliance. Methodological framework for fine calculation. The EDPB outlines a 5-step methodology for calculating fines, starting with identifying relevant processing operations and assessing the applicability of Article 83 of the GDPR. The process includes determining a starting point for fine calculation based on the violation's nature and severity, considering the entity's turnover, and evaluating both aggravating and mitigating factors before arriving at a final amount. This method emphasizes a tailored evaluation over a rigid formula, acknowledging the unique circumstances of each case. Key factors influencing fine determination. Infringement classification and seriousness. Violations are categorized based on the GDPR's provisions, with fines proportionate to the infringement severity and the entity's annual turnover. The nature, scope, and duration of the infringement, alongside the number of affected data subjects and the extent of the harm caused, play critical roles in this assessment. Methodology for calculating fines. The EDPB outlines a 5-step methodology for the calculation of administrative fines, ensuring a structured and reasoned approach. Identifying the processing operations. This step involves assessing the processing operations in question and their compliance with the GDPR. Determining the starting point for calculation. Based on the nature and severity of the infringement, a starting point for the calculation is identified. This considers the classification of the infringement under the GDPR, the seriousness of the infringement, and the turnover of the undertaking. Evaluating aggravating and mitigating circumstances. Past and present behavior of the controller or processor is reviewed, and the fine is adjusted accordingly. Identifying the relevant legal maximums. The guidelines ensure that any increases or decreases in the fine do not exceed the legal maximums set by the GDPR. Ensuring effectiveness, proportionality, and dissuasiveness. The final amount is adjusted to meet these requirements, ensuring the fine is tailored to the specific case without exceeding the legal maximum. Practical implications for businesses. The guidelines underscore the importance of proactive GDPR compliance strategies, highlighting the financial and reputational risks of non-compliance. Organizations are advised to implement robust data protection measures, regularly review their compliance posture, and foster a culture of privacy awareness to mitigate potential fines. Conclusion and future outlook. The EDPB's guidelines reflect a commitment to ensuring that GDPR enforcement is balanced, fair, and reflective of the regulation's overarching goals. As digital data processing becomes increasingly complex and integral to business operations, these guidelines will undoubtedly evolve. Continuous review and adaptation will ensure they remain relevant and effective in promoting a culture of data protection and privacy across the EU. In summary, the EDPB's guidance on calculating administrative fines is a cornerstone of GDPR enforcement, providing a clear framework for supervisory authorities and offering businesses insight into the regulatory landscape. By adhering to these guidelines, organizations can better navigate GDPR compliance, minimizing the risk of financial penalties and contributing to the broader objective of protecting individual privacy rights in the digital age.